calling the last case of the morning, and this is case number 166790, Swoope versus Citizens Insurance Company of the Midwest. A mini oral argument on the application, both sides having 15 minutes of argument. Again, 2 minutes of fire-free zone. Any rebuttal time that you'd like to save, just keep track of it, please.
Thank you, Madam Chief Justice. Jason Blankenship on behalf of Ms. Swoope. I'd like to reserve 2 minutes for rebuttal, if I may. This court asked the parties to address one question: whether the plaintiff is barred from recovering personal protection insurance benefits under the No Fault Act because at the time of the accident she was willingly operating or willingly using a motor vehicle that was taken unlawfully, and she knew or should have known that the motor vehicle was taken unlawfully. Plaintiff answers no, she was not barred from receiving those benefits because she was not using a motor vehicle that was taken unlawfully, and she did not know and should not have known that it was taken unlawfully. The purpose of Michigan's No Fault Act is to provide victims of motor vehicle accidents assured, adequate, and prompt reparation for certain economic losses, regardless of fault. The Act itself states personal protection insurance benefits are due under this chapter without regard to fault. The instant case is before this court as a result of the Court of Appeals inappropriately conflating two issues: the unlawful taking of a motor vehicle and the unlawful use of a motor vehicle. As a result of this inappropriate conflation, the Court of Appeals injected fault back into no fault in contravention of Michigan's No Fault Act. If the decision of the Court of Appeals stands, as a consequence of that decision, a person charged with reckless driving might be denied no fault benefits, or the medical providers who treated the injured person might not be compensated for the care provided. Again, the Act itself says regardless, without regard to fault. The No Fault Act does not bar recovery by victims of motor vehicle accidents by unlawful use of a motor vehicle only for the unlawful taking of a motor vehicle. The plain meaning of the phrase taken unlawfully in 3113A refers to gaining possession of a vehicle contrary to Michigan law. 3113A does not encompass the unlawful use of or operation of a motor vehicle. What the Court of Appeals has done here will have a dramatic effect on injured persons as well as on those providers who treat the people following accidents. Plaintiff Swoope allegedly violated MCL 257-301, which requires drivers to be licensed. Yet it was only when she began driving the vehicle that she violated the section. Merely existing without a driver's license is not a violation of law. Similarly, there's a distinction between unlawfully taking and unlawfully using a vehicle. The trial court got it correct, and the Court of Appeals got it wrong. There's a question of fact for the jury to decide. Ultimately, we think that Ahmed was wrongly decided, as was Swoope, but in order to reverse Swoope, this court doesn't need to reverse Ahmed. The three prongs of the Ahmed test are, of course, willingly operating or willingly using a motor vehicle. No one's contesting that. She was clearly driving a vehicle. That was, at point 2, that it was unlawfully taken by someone, and that point 3, the person seeking benefits knew or should have known that the motor vehicle was taken unlawfully. Was the vehicle unlawfully taken? Plaintiff and the owner were longtime friends. She's staying at the owner of the vehicle's house that night. According to the Court of Appeals, citizens, and various amicus briefs, plaintiff's taking the vehicle was unlawful because she didn't have a license. That's the express holding of the Court of Appeals in Swoope, as to the second prong. But again, it's perfectly legal not to have a license. Only when somebody drives without a license does that conduct become unlawful. All of this falls apart when you go back to this court's ruling in Spectrum. The driver there, Craig Jr., I'll use their first names because they have a Craig Sr. and a Craig Jr., the driver there was unlicensed in Spectrum. This court could have answered the questions in Spectrum without ever getting to the joyriding statutes, which were a necessary part of the holding in Spectrum. Had driving without a license been sufficient to trigger the statute? And it doesn't matter whether it was the old statute or the new one for this purpose. Where the Court of Appeals ruling in Swoope sort of falls apart is its reliance on Ahmed. The Swoope decision cites to Ahmed saying that any violation of the criminal law that leads to a taking of a motor vehicle will constitute an unlawful taking for purposes of 3113A. Fine, but neither Ahmed nor the Swoope decision explains how the violations of the motor vehicle code lead to a taking. Violation of the licensing action only happens when you use the car. It doesn't happen when you take the car. Likewise, 257 310E4, the underage driver section, does not address taking at all.
So maybe, say we agree with you that the lack of a license or a valid license is irrelevant for deciding whether it was unlawfully taken. But is it relevant for determining whether or not the plaintiff knew or should have known that she took the car without authority?
I don't think so, because again, in this, in the particular facts here, long-term relationship with, with the owner of the car, they're very close friends. Again, if knew or should have known that that he was not entitled to use the car, as I believe your question, Chief Justice, correct? Mm-hmm. Then, again, we go back to Spectrum. Same thing is true of the driver in Spectrum. He didn't have a license, and there's also express prohibition by the owner of the car, Craig Sr., in Spectrum.
So is it your position that a taking is unlawful only if the owner expressly prohibits it?
I think in the facts of this particular case, there's a fact question for the trial court to address. I think there can be situations where a taking could be unlawful. For example, I think in the companion case for Spectrum, I think that the facts there weren't necessarily a express prohibition, and were held by this court to be an unlawful taking. But here, I believe we have here in Swoope, I believe we have a fact question.
So help me understand, like, what is the fact question here, right? What is the specific record evidence that supports that she had that? I get that you said she had a friendship. She didn't testify that she had, in fact, authority to take the car, right? She admitted that she didn't have, I had no permission to operate it. And she had never driven it before. So what is it that you think raises a question of fact to whether or not she actually had authority?
I think in part of the problem here is that the Court of Appeals also made a conclusion of fact about what happened. And I think that the trial court record, again, we talk about the long-term relationship between the parties, her application for benefits to the signed claim said that she had permission to use the vehicle. The distinction between express permission and the implied permission. If you look, for example, at the Amos case, unpublished, which was cited in my brief, that one, there was a familial relationship. Admittedly, family is different from friends, but with close friends, if my mother were in a medical emergency, as happened here, and I did not have the opportunity to specifically ask a friend for their car, their keys, and took the vehicle, given our relationship, I would feel entitled to do so. That's ultimately going to be a question of fact for the jury. I mean, obviously I have a license and I have insurance, but it's also obviously going to be a question for the trier of fact to answer as to whether or not that under those circumstances I was entitled to do so.
Counsel, I'm wondering how 500.3177 factors in, that is the provision that allows the fund to basically go back against the owner of the vehicle and seek reimbursement for funds paid out if in fact permission was given. I'm wondering, does that factor into our analysis at all, or we just don't worry about that? I realize that's getting into like looking at other statutes.
But I think it's a good question, because again, it goes back to the purpose of the No-Fault Act. Because the point of the No-Fault Act is to make sure that people who are injured are compensated. And so under your question, under the reimbursement provisions, it's a separate proceeding. I think that the question is, should Ms. Swoope and her providers be compensated for the medical care and the benefits? That's one thing. Does that go after the owner of the vehicle for, giving a vehicle without, in circumstances like this? That is a separate question. I hope that makes some amount of sense.
Thank you.
Counsel, just to backtrack a little bit to make sure I understood your answer to the Chief Justice's question regarding the fact issue here about knew, should have known. Am I correct in understanding that it's the circumstances of her taking the keys in this case where there's a medical emergency? It's not going out to buy milk or cigarettes. It's in circumstances right here, taking the keys to drive for a medical situation.
That's correct, Your Honor. She got a call from her mother that her mother was having a medical emergency and was going to the hospital, and she was not in a position to be able to do anything other than respond to that medical emergency.
Okay.
Counsel, what would a jury instruction look like on the fact issue here?
That's a good question. I hadn't necessarily thought of that in that terms. I suppose I can craft something for you. It may wait on rebuttal, but off the top of my head, I think the jury instruction would be: was Ms. Swoope's belief that she had implied permission to take the vehicle reasonable? Should she have known that she did not have that permission? That's first blush, under the gun, so to speak. So more artful words may follow, but that's what I've got for you at the moment.
Thank you for working that out on the fly.
Unless there are any other questions, we would just ask that this court reverse the Court of Appeals and remand it back to the trial court. Thank you.
My name's Erin Sedmak. I represent Citizens Insurance Company of the Midwest. So in this case, we do have an unlawful taking within the meaning of 3113A because every element of the statute's plain language is met. First, there's really no dispute that she was willingly using or operating the vehicle. Second, there was an unlawful taking in violation of the joyriding statutes, both of which, as this court explained in Spectrum, prohibit a taking without the owner's authorization. Here, there was no authorization given by the owner for the taking. Third, the plaintiff knew the taking was without the owner's authorization because she testified as much. She testified she took the keys from her friend's purse and she took the vehicle without permission. So here, really, my understanding of plaintiff's argument is that there is somehow a question of fact because she argues there was a subjective belief she had implied permission because there was a perceived medical emergency and no express prohibition. And so I do want to address each one of those because I think there's 4 primary issues with those arguments. The first issue is that the argument really contradicts what this court said in Spectrum when it defined what an unlawful taking is in violation of the joyriding statutes. which of course is a taking without authorization. An authorization is an affirmative act. It means to grant permission or to otherwise sanction. Without that, the absence or lack thereof means it is a taking without authorization. So it really has nothing to do with going against express prohibition, or it certainly is a taking without authorization, but it is the lack of authorization. There's really nothing in the joyriding statutes or 3113A that requires an express prohibition. The second problem with that argument is that if you're going to require an express prohibition, it is effectively presuming consent in the absence of an express prohibition. And this court already rejected the concept of applying presumed consent under 3113A for lack of a statutory basis. And then the third issue is that this argument really relies on not an exception to an unauthorized taking under 3113A, right? Based on someone's subjective belief that their taking was reasonable or they had an excuse. But 3113A does not include any kind of exceptions such as, an exigent circumstances exception or the language that from the former statute that said somebody's excluded from recovering benefits if they unlawfully take a vehicle unless the person reasonably believed he or she was entitled to take the vehicle, right? So that allowed you, even if there was an unlawful taking, to kind of escape the penalty under 3113A. But the legislature removed that from the statute. So now what we have today is a statute with 3 affirmative elements that must be established, not any exceptions. And the fourth argument is really, I think, a confusion between the concept of implied permission versus an excuse for an unauthorized taking. So implied authorization still is authorization, right? There is authorization. It is not a taking without authorization. An excuse for an unauthorized taking is an unauthorized taking still.
Can you illustrate what would be an example of those two different things?
Sure. I mean, like anything in the law, you can expressly say something or you can impliedly say it. So if you're walking to the car and you say, hey, you're 16 now, and you toss somebody the keys and point at them and wink, I would say that's implied consent to then drive the car that you're both walking to. They may not have expressly said, you may drive my car, but it's implied through the actions, right? It is still authorization. Now, there are some cases, and I'm actually glad you brought that up, that kind of confuse this point because they base it instead on something like a familial relation, like an Amos, right? But this court already said there is no, family joyriding exception. Why? There's no classes of persons that are immune from 3113A or are treated differently under 3113A. So when you're looking at an argument over implied consent, you have to focus, the evidence has to be on the authorization, not the relationship. Not, oh, I have a close relationship with someone. And this case actually illustrates that. Because here, Ms. Swoope argues, hey, I knew the owner for 4 years. We were friends. But there's nothing inherent about a relationship with somebody for 4 years that really speaks to authorization to take their vehicle.
Counselor, so you highlighted there are 3 requirements for the statute. There's the use, there's an unlawful taking, and then there's the knew or should have known part. And so I'm struggling under your reading how you would have a case where the car was taken unlawfully, under your understanding of what that means, but that the person wouldn't know or should have known, right? So I'm not seeing any distinction between those last 2 elements under your reading. So help me see that.
Sure. So when there is a taking in violation of the joyriding statutes, it's without authorization. And then 3113A asks, and actually I do believe plaintiff's counsel agreed with me on this, the statute asks, did this person know it was unauthorized, or should this person have known it was unauthorized? But in either case, it's unauthorized, right? There's never a situation where it's like, well, I had a reasonable belief it was authorized even though it wasn't, right? That is the old statute. It doesn't exist.
But why do we then have the third element of the test that you've highlighted? So you're saying once you get to unlawfulness, then we don't even need to ask about knew or should have known?
You do. Because under Brambin, which was pre-amendment, that said, well, in order to violate the statute, you must actually know subjectively that your taking was without authority. Under the statute as it exists today, the legislature has said no, you could subjectively know, or objectively, if you should have known, you are subject to the penalty under 3113A.
Can you give me an example, following up on Justice Thomas, of where somebody meets the first two elements but wouldn't meet the third?
I would say if there's no authorization and you take the car without authorization, and then, I mean, again, if you cannot plead subjective ignorance to avoid 3113A if there are facts showing that you really should have known. And I mean, this is a good example. First of all, there's no evidence that there was any authorization.
Yeah, I think we're arguing, my question isn't artfully worded. I think I'm trying to figure out if the statute requires all three elements, then there must be a point to that third element, meaning that it's that somebody who meets the first two still may not be subject to 3113A because they didn't know or should have known that the taking was unauthorized. So who is that person? Where is that scenario in which it was taken without express or implied or authorization? We've gotten past two, but they didn't know nor should they have known that they didn't have authority.
I think in a situation maybe where there's an intermediary and the person does not realize that they did not have the owner's consent, but there are facts where they probably should have known. There were signs that it was someone else's vehicle, not the person who gave it to them. So that would be a should have known situation. Maybe.
So we've engaged in a lot of this discussion about this. What do we do with the Court of Appeals opinion in this case that seems to, didn't seem to engage in all of this permission, implied, express, prohibition, all of that? They said the lack of a valid license.
Yeah, that was not, admittedly, I do agree that they kind of combined the second and third elements in their analysis, and it wasn't a model of clarity. Now, they did cite a lack of permission, right? But they really did focus a lot on this idea that she wasn't licensed, and I think really, to the extent that's relevant, it would have been under any analysis whether she should have known. It is objectively unreasonable to presume you have authorization when you can't even legally drive a vehicle. I would say that is the extent it's relevant here. But really, primarily, it is objectively unreasonable to take a vehicle when there's really no evidence of authorization. So in this case, she certainly knew it was without authorization, and certainly also should have known it was without authorization.
So counsel, you've argued that Rambin, is your main argument Rambin just doesn't apply because there were amendments? Okay, but so the amendments completely got rid of like a mens rea requirement, even though it should have known, or,
Well, I think it gave a mens rea. It gave the scienter requirement that is required for 3113A to apply, right?
So why would should have known not be in dispute here? In your argument, it's just because she didn't have a license.
Well, she actually, I don't think personally, it has to do with whether or not she knew there was authorization or not. So I think in the Court of Appeals, they kind of talked about, well, she didn't have a license, right? To the extent she didn't have a license, it's unreasonable to presume consent. I think that's the wrong analysis, though, because there is no presumed consent, right? But if you're looking at the whole picture of facts here, even if she says subjectively she didn't know if she had authorization, even though she admitted that on the record, all the facts would matter, okay? Why do you think you have consent, even though you didn't, right? Certainly not being able to drive legally is an issue. But then you also think, have you ever driven this car before? Have you ever gotten permission to drive the car before? Other facts could matter. But really the violation here is the violation of the joyriding statutes. And I do want to address that kind of discussion of taking versus use that was in a lot of the briefs in the amicus, because the 3113A, I do think you have to be faithful to the statutory language, and it penalizes an unlawful taking. And in Spectrum, this court defined what that meant in, where there's a violation of the joyriding statutes, and it was without authority. And they said, okay, when you have the word take isn't defined in the statute, you use the common ordinary meaning of the word. And in Spectrum, it said the common ordinary meaning of the word was to get one's hands on or gain possession through voluntary action. So to obtain or to get. And that's certainly a definition, but it is not the only common ordinary definition of the word. Another just as common, just an ordinary definition is to take something with you, to bring it from one place to another. And that's really what both joyriding statutes prohibit, because there are two. And one is a felony and one is a misdemeanor. And they don't prohibit the same conduct, right? So it's explained in case law that the felony offense has more than one element. You have to both take possession and you have to take or drive away. Both must be satisfied. The misdemeanor offense applies when someone has lawful possession, but then they take or use without authorization. Now, while an unlawful use may not be a violation or subject to the penalty under 3113A, certainly an unlawful taking under the misdemeanor statute is. And Spectrum confirmed that a violation of either statute forms the basis of an unlawful taking. And I think under any definition of taking here, you have an unlawful taking. But I bring it up only because if this court was to not deny leave and to do an opinion on MOA, they should clarify, because there has been some confusion in the lower courts over that. And actually, your question, or maybe it was your question about section 3177, I think really speaks to that. Because there was a case that was held in abeyance where the mother was a snowbird. She left to go to Florida for the winter. She left her vehicle in her son's garage uninsured, and she said, hey, don't drive the vehicle, it's uninsured. And he drove the vehicle and was involved in the accident. And under the No Fault Act, not some other act, but the No Fault Act, it says the owner of that uninsured vehicle is on the hook to repay the insurance company, not just for the PIP benefits, which could be significant, but their costs and attorney's fees. So if you don't have the unlawful taking, under both joyriding statutes, then that person, to mom, is subject to repayment of that.
Thank you.
Well, that's all I have to say. If you have any more questions, I'd be happy to answer them.
Thank you.
Thank you.
Mr. Blankenship, you have 2 minutes and 42 seconds left for rebuttal.
Excellent. I don't anticipate using them all. I just want to raise 3 points. If the legislature had wanted to say without permission, it certainly very well could have done so in drafting 3113A. That's not the language. We have the language that we have. Sister counsel was arguing that you couldn't presume a lawful taking without a license, and I don't think that's correct. And then I think both Justice Thomas and Chief Justice Kavanaugh really made my point better than I did, which is that the third section, knew or should have known, has to mean something. If it doesn't, then why is it in there? All of these questions about, you know, the relationship between the parties, did she have a relationship such that they would borrow each other things? These are all questions to be argued at the trial court, to be explored there. It very well may be, as a factual matter, that Ms. Swoope loses at trial, but that's where she should lose, if she should lose, would be at trial, not on appeal. Again, we would just ask that this court reverse and remand the Court of Appeals, reverse the Court of Appeals and remand it back to the trial court. And unless you have any more questions for me, thank you for your time.
Thank you. The case will be submitted, and the court will stand adjourned until 1 o'clock this afternoon. Thank you.